The minor accused in the Pune Porsche case, who has been in an observation home in Pune for the past month or so, has been asked to be released immediately by the Bombay High Court. And in doing so, the High Court made some very strong remarks on Tuesday, talking about the haphazard manner in which the entire prosecution agency approached the issue, being rattled by the public outcry, and how, regardless of his crime, the juvenile accused must receive the same treatment which every other child in conflict with law is entitled to receive under the law. The court said that while the court has sympathies for the victims and their families in this case, it has to implement the law as it stands. Now, we know that the 17-year-old's late-night Porsche drive on 19th of May resulted in the deaths of two 24-year-old engineers, causing widespread outrage across the country. But why has the Bombay High Court asked him to be released now? I, Apoorva Mandhani, will explain to you in this video. Now, we know that the 8-month-old minor was produced before the Juvenile Justice Board, Pune, on the date of the incident, that is 19th of May, and was released on bail the same day. He was let off with a directive to write a 300-word essay on road accidents and a referral to an alcohol de-addiction center. This was also an order that had led to widespread uproar across the country. 2 days later, the prosecution filed an application under Section 104 of the Juvenile Justice Act 2015, seeking to review the earlier bail order based on new evidence, including CCTV footage showing the minor consuming alcohol and smoking before the incident. Now, just to let you know, Section 104 allows the board, which is the Juvenile Justice Board, to amend its own orders regarding the institution to which a child is to be sent, or as to the person under whose care or supervision a child is to be placed under this act. So essentially, this application was filed for a review of the bail order under this provision. While the prosecution application was not for cancellation of bail, this application resulted in an order passed by the board on 22nd of May, restoring him back to the rehabilitation stay at an observation home in Pune till 5th of June. The board also launched a comprehensive procedure for his rehabilitation, passing several directives, referring him to experts and preparing him for a de-addiction program. This stay at the observation home was then extended on different dates by the board till 25th of June. Now, the minor's paternal aunt Pooja Jain, in the meantime, approached the Bombay High Court demanding his release from the abjectly unlawful and arbitrary custody and incarceration. These were the allegations that she had made before the Bombay High Court. So essentially, the High Court has now quashed these remand orders that I told you about earlier, extending his stay in the observation home, in fact sending him to the observation home and then extending those orders, taking note of the provisions of the 2015 law. This law says that only if a child is denied bail by the Juvenile Justice Board shall he be kept in an observation home or a place of safety during the pendency of inquiry regarding him. The High Court asserted that Section 104 is limited to changing the institution or a person under whose care a child is placed, and does not involve depriving the child of his liberty if he is already out on bail, which was the case in this case. In doing so, the court called it a classic case of how the law enforcement as well as the law implementing agencies reacted to public outbursts. It expressed its dismay over the approach of the investigating authorities in the case, and the court then asserted that even though the law enforcement agencies succumb to public pressure, rule of law must prevail in every situation. The court also said that the outcry as a knee-jerk reaction to the accident, resulting in a clarion call of see the accused's action and not his age, will have to be overlooked. So it essentially said that this outcry needs to be overlooked when deciding such a case. And while ordering his release, the court clarified that if the minor has been referred to a psychologist or is undergoing therapies with de-addiction center, he shall continue participating in these sessions. Additionally, while quashing the remand orders and directing his release, the court also directed that the minor shall continue to be under the supervision of his paternal aunt, who had approached the High Court, and she should ensure the compliance of the necessary directions issued by the Juvenile Justice Board to assist him to be rehabilitated. That's all I have for you right now. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.